Good morning, Ms. Brown. How are you?
Hey, good morning.
All right, so Ms. Brown, you're charged with interstate. I'm sorry, the whole charge is not. Um, got one, two, three counts of interstate custody. And these are warrant numbers 2023 CW 50242 and 43, as well as 44. Attorney Rogers is handling this matter. Go ahead, Attorney Rogers, your motion.
Thank you, Judge. Judge, I guess a couple of things I would like to talk about before we really get too deep into it. I want to kind of talk about what's being alleged here and this is coming from the warrant. And I've seen an initial police report. I couldn't determine exactly what officer filed, but I've seen an initial police report, so that's another source of what I will say. And then obviously from speaking with Ms. Brown. But essentially these charges, she's charged with interstate custody, interstate interference with custody. I guess I'll start with what this case is not. Number one, I have not seen any factual allegation that anything happened out of the state. Number one, so I want to be very clear about that. What I've seen is, and this again is based on the report and the probable cause affidavit, is that here in Georgia, the custodian of the children, let's be clear, just further about what we're talking about. These are Ms. Brown's children, number one. These are not anybody else's kids. We're talking about her children, number one. However, the paternal
How many is it?
Three.
And what are the ages?
Judge, give me a second. I'll see if I can get them in front of me. Yeah, I know. I think one of them was like 9.
Can she just tell me the ages? Ms. Brown, just tell me the ages.
So my oldest just had
I like to know what I'm dealing with.
So if I'm not mistaken, she just turned 12. And my middle daughter
12.
Had a birthday September the 5th. She just turned 11. And the youngest daughter is 8 years old.
All right. Continue, Attorney Rogers.
Okay. And so, Judge, so like I said, these are her children. So I want to be clear about what we're talking about. The paternal grandmother is the person who had custody at the time. There seems to be some discussion from what I can understand, and we're not without agreeing that the order is valid or was legally obtained, just conceding that we are aware of an order out of South Carolina awarding custody to Ms. Carter. What that order did not do, as far as I've seen, and I haven't seen any allegation, what it did not do is terminate Ms. Brown's rights as a parent. It's strictly a custody determination, number one. Number two, the allegations, they start immoral. The warrant and the report, they contemplate all these ideas and these hypotheticals about where the kids could be, this, that, and the third. I haven't ever seen any evidence that says that the children were ever out of the state, that they were recovered out of the state, that Ms. Brown was found out of the state. So, this idea that the interstate part, was based strictly, as far as I can tell, on conjecture. So that's my first situation is that, and I understand, it's not a prelim, but I just want the court to know what our position is. It's not an interstate issue, number one, if nobody's ever alleged to have left the state, or nobody's proven there's no evidence anybody ever left the state. Number two, this is not a case where somebody enticed children or anything like that. The allegation comes down to Ms. Carter is supposed to have willingly allowed the children to be with their mother, consistent as well. I'll say the order that, as discussed, is supposed to be that Ms. Carter has custody, but that Ms. Brown can have visitation consistent with Ms. Carter's. Okay. The allegation comes down to they claim that the children, were left to go with their mom in May, I believe it was, and we're supposed to, and this, we're not agreeing to this, just laying out the allegations. Supposed to have been returned in August. The report is made in, I want to get it in front. If I can have one moment, Judge, I just want to make sure I get my dates right.
October, if I'm not mistaken.
Yeah, that's what I thought. And so the report is about a month, 2 months, give or take, after the children are purportedly supposed to have their return. I would say that raises some concern where if you waited a month or so to report these children missing, apparently that kind of undercuts the idea that this was without your permission. Number two, the officer in the report, I don't know if the court has access to the initial report. I've spoken to the state. I know ADA Thomas said she has seen the report. If she don't have any objection or anything, I'd be glad to forward, the report that I'm referring to the court. But what it comes down to is that they claim that she was supposed to return the children, didn't. The officer in that initial report shows a lot of skepticism about the charges. And I understandably so. He notes that at one point he notes that the text messages that Carter is showing to try to substantiate her case appear to have messages deleted. This is what the officer is saying in his report, that it appears that messages were deleted. There's also a part in which the officer notes that Ms. Carter appeared to be giving physical custody to Ms. Brown. This is what the officer's review of the report of the text messages presented by Ms. Carter. This is what that officer is saying about those things. Additionally, I've seen no mention of any sort of evidence of any discussion of a date when the children are supposed to be returned. Like that, that's what Carter is saying. But the officer doesn't mention seeing text messages to that effect. Nobody's showing any documents to say that that's what the situation was or anything like that. So that's why I say a lot of this is strictly, conjecture, hypothesis, people trying to muddy the waters on the situation. The other thing that I would note is that officer questioned why she was only reporting it when she did, Carter that is, in light of what she was saying about the situation. And I saw those things to say that, like I said, this is not some situation where we're talking about, borderline kidnapping or she lured the kids to come with her or anything like that. This is a mother, being with her children. Another thing I would say is that when we talk about interference with custody cases, people, a lot of times I see the court treat it as if the alleged victim is the children in the situation. But the whole issue is that somebody else has custody. So if anybody's supposed to be the alleged victim, it would be the person, the so-called custodian in the case, not the children. Nobody's alleged to have done anything to the children. But what we'll hear about is that there's a stay away order that prevents Ms. Brown from having any contact with her children. And that's another thing I want to get clear on. Not asking the court to overrule, set aside, alter any other custody arrangement. All we're asking for is that the bond condition be modified from a complete stay away to one that allows contact consistent, with any family court orders or custody designations. So we're not asking the court to overstep its bounds or do anything that will run afoul of its authority. We're simply asking that the court not have this case be the reason that Ms. Brown cannot have contact with her children. And one of the reasons, well, I guess I'll say it in a couple of different ways, but one of the reasons is that Ms. Brown, for one, has not been able to wish her children a happy birthday. She's missed that opportunity for two of her children to even wish them a happy birthday, Judge. And I want to point out, Ms. Brown has been adamant in speaking with Ms. Thurman, that's the Superior Court attorney from my office at the family case, and, about coming before the court and trying to do things the right way, as opposed to, trying to go around the court's order. That's why we're here this morning, because Ms. Brown wants to do things the right way. I know that there's, the state will have this argument that, she did this and she did that. But again, far as I can tell, unless the state's got some evidence that I haven't seen in the report or in the warrant, it's just based on people with no direct knowledge of the situation. And so, like I said, I want that's my first issue with this case is that that's what kind of interstate interference with custody charge that we're hearing here. No basis to say that there was any movement out of state, and no enticing or anything like that. The children were willingly given to Ms. Brown's custody. Additionally, like I said, that the stay away, if anything, it would make sense maybe for it to be against Ms. Carter. Excuse me, not against Ms. Carter, but to stay away from Ms. Carter. If anybody's the alleged victim of my position, if the charge is about interfering with custody, the alleged victim will be the custodian, not the children. And so that's another reason I would be asking the court to modify the condition from a stay away to merely one that she can have contact consistent with any family court orders, custody designations, things of that nature. The other reason that besides just the parent-child relationship that's kind of being torn asunder by this order is that Ms. Brown has concerns about the children's welfare, both in the sense of whose custody they are in, and she's not even allowed to ask the children, make contact with the children, to ask how they're doing, to see about whether or not some sort of reports or things like that need to be made to authorities about the children. Additionally, and this is from speaking with Ms. Brown about, I guess, what she's other family members, and again from the report, the initial report, there's discussion about Ms. Carter, the custodian, being a resident of Florida, most recently possibly Ocala, Florida. I'm sure the court is aware there's been some hurricanes down there lately. Ms. Brown, under this order, in compliance with this order, is not even allowed to check to find out if her children are okay as far as in terms of a hurricane, Judge. And that's my issue, is that this order is just gone to make it a complete stay away, just goes above and beyond what's required to address any concerns. That we're not asking that the court award custody to Ms. Brown, not asking the court to order visitation or anything like that. So like I said, I want to be very clear. We're not asking for much, I don't think. We're asking merely for her to be able to say happy birthday to her children, to say, did you guys survive the hurricane? Things like that. And so the fact that Ms. Brown has refrained from doing those things, that she's here this morning, implies that she's trying to do things consistent with the law. So, Judge, for those reasons, the fact that, like I said, there's really no evidence supporting the interstate charges, number one, the interstate aspect of the case, number one. Number two, what's being offered, like I said, doesn't even support an interference with custody charge, to my mind, for what I've seen, unless we just take Ms. Carter's word where it's problematic for Ms. Brown and ignore the fact that she waited these 2 months to report it, that the officer is seeing what appears to have been deleted text messages implying that she's not representing things accurately about the situation. That the officer did see text messages where it appears that Ms. Carter is giving custody to Ms. Brown. And the fact that under the circumstances, the stay away order has gone above and beyond what a family court has decided was reasonable. Like I said, there's been no argument that her rights are terminated or anything of that sort. So for all those reasons, Judge, that would be why what we're asking for I think is certainly reasonable, in that she'd be allowed to have some contact with her children, to check on their welfare, to wish them a happy birthday. And I would also note the flip side of it, because, like I said, they're not the victims in this case, number one. But number two, if anything, the order is affecting the hardship on the children. Because the flip side is, these children, who nobody's alleging to have done anything wrong, are being deprived of contact with their mother. You know, Ms. Brown has talked to me about how her children reached out to her, I guess, you know, whatever media they have, and she can't respond. So now these children, for her to comply with the order, she has to give the children out there that she's, you know, not concerned with them, doesn't want to talk to them. So at this point, like I said, the order is just, it's doing more than is needed. And for all those reasons, Judge, like I said, I'm strictly asking for a modification of the condition to allow her to have contact with the children and be contact consistent with any family court orders. But we certainly think that it's a reasonable modification to allow a mother to have contact with her children, especially when there's no allegation that she's harmed them physically, done anything of the sort. So for all those reasons, Judge, I'd ask that you would modify that bond condition to allow her to have contact with her children. Thank you.
Okay. Go ahead, Attorney Thomas.
Your Honor, I'm going to say upfront that the order, after reviewing it, does not preclude her having contact with the children's guardian, which apparently is her mother, Ms. Carter. That order was issued on April the 1st of 2019, and at the time, it allowed her to have visitation with the children supervised either by Ms. Carter or by another person appointed by Ms. Carter to supervise the children while she's visiting.
Yeah.
Unfortunately, between 2019 and
88, just a point of clarification. When you said the order, I just want to make sure we're clear about which orders
we're talking about the bond order that you're trying to modify that was issued on the 8th of May of 2024. The only persons on this bond order that she is required to have no contact with are the 3 children that I'm not going to list because we are on Zoom. We are on YouTube, Your Honor. But the 3 minor children at issue are the only ones that she's required to stay away from, and she's also required to have no further violations of bond. It does not preclude her from reaching out to the children's guardian, asking that guardian how the children doing, wishing the children happy birthday. She could possibly send a card or ask the guardian to get a card for the children. Everything has to be done through the guardian. Initially, the South Carolina order would allow her to have contact with the children. Unfortunately, between the time that order was issued to this year, Ms. Brown has violated the conditions at least twice, where she has, and Ms. Carter, stepping out on faith, I would imagine, allowed her to have visitation with the children unsupervised. Yes, sir. Would you like for me to continue on, or we want to find out what's going on with the jail?
Oh, yeah. Deputy?
He just logged off and then logged back on. That's all.
Oh, okay.
Oh, okay. All right.
Ms. Carter and Elizabeth, ma'am?
What is the violated conditions?
She was not supposed to have unsupervised visitation with the children. Ms. Carter, for whatever reason, allowed her to do that, and then she absconded with the children, which is how she ended up being charged. In fact, Your Honor, she has 3 counts here in Clayton County, and then she has another count for the exact same thing in DeKalb that's still pending. She runs off with the children. They have to hunt the children down and get the children back. That's how she ended up in the position of having no contact with them at all. Now, I will concede part of this may be Ms. Carter's fault in that she trying to encourage a relationship with the children and their mother would allow her to have unsupervised visitation. But at this point, whenever that has happened, she's run off with them. So state would ask at this time that if there is no reason why she can't reach out to the guardian to extend happy birthday wishes, there is no reason why she can't reach out to the guardian to determine whether or not the children are safe and well after the hurricanes. There's nothing in that bond order that precludes that. The only thing that bond order says is that she cannot have any contact with those children. And state would ask at this time, unless she gets that modified, unless she gets something done by the court who originally issued the order, state would ask that it remain that way. There's nothing stopping her from following up with the status and welfare of the children through the guardian. She just cannot have contact with them.
All right, final words.
Yeah, I can't hear you.
It kind of broke up, Judge. I wasn't sure if 88 Thomas was done or not, but it kind of broke up, Judge. Can you hear us okay?
I broke up with the judge.
Okay.
No, the judge.
Yes, I can hear you now.
In fact, Your Honor, I want to add one thing to it. The incident that led to these charges here, where the grandmother trusted Miss Brown to be with her children and return the children, the grandmother actually did wait almost 2 months before she reported it, in the hopes that Miss Brown on her own would return these children. Miss Brown cannot be trusted with contact with the children at this point. State would ask that the bond condition of no contact remain.
Okay. All right.
And Your Honor, that's
Final
all I
words,
have.
Attorney Rogers. Thank
Thank
you.
you, Judge. I will respond to what 88 Thomas said. That's just part of it is just factually incorrect. The order says she has to stay away from the children, absolutely, directly or indirectly, from the person, home, workplace, and immediate family members of any witness, including but not limited to, and then a list of children. That means, and that's pretty much standard on stayaways, is that, yeah, you're not allowed to have contact with the people listed indirectly or otherwise. So if she sent a card with the intentions of that making contact with the children, that would be a violation of the order. That's the very problem that we have with the order as it is, Judge. Additionally, the state points out that there's an order, a family court order, controlling the custody situation. Again, we're not asking the court to alter anything about that. We're simply trying to get the order modified so that Ms. Brown can have contact with her children, so that she can check on them. Because again, like I said, part of the concern is the person whose custody they are in. They've had legal issues before. Ms. Brown has taken out charges against her for Ms. Carter's behavior. The relationship is somewhat acrimonious at times, I guess. So I certainly don't want to sit here and present it as if the requirement that or that she could go through the person, Ms. Carter. And speaking with Ms. Brown, one of the issues is that Ms. Carter refuses to have contact, period. And that's fine. That's not who we're here about. We're not seeking contact with Ingrid Carter. That's really neither here nor there. The issue is that, like I said, if the children reach out to Ms. Brown and say, "Mom, I need help. Mom, we're being threatened, abused." If they say any of these things under this order, Ms. Brown's not supposed to respond. She can't have contact to follow up with her own children. That's the issue. The family court order didn't bar contact. That's not what the court in South Carolina orders from. Didn't bar contact. It allowed for supervised visitation. There's nobody saying that her rights have been terminated. My position is that the order completely barring contact goes farther than the family court's order.
Yeah, I'm going to have to interject on this one. I believe defense counsel indicated that there's nothing barring her being a parent. My understanding of the South Carolina order is that Ms. Carter was appointed the legal guardian of the children. Let's say it exactly right.
That's still not a termination.
Legal custody.
Right.
The order that was signed on April the 1st of 2019, Ms. Ingrid Carter was awarded legal custody of all 3 children.
Right.
Which did provide for Ms. Brown to have supervised visitation. But the legal guardian of these children is the grandmother, Ms. Carter.
Yeah, that's not.
I'm actually ready to. I'm ready to rule. We don't even have to go much further. All right, and so I am going to modify the bond condition where she can have communication, but only by phone, mail, Zoom, FaceTime, that sort of thing. She cannot have physical contact, but she may communicate with them in other means. She can call them, she can email them, she can FaceTime with them. So I'm going to modify it.
Did that be within that be prearranged with the guardian to coordinate a time that would be best for the children. So she's not calling.
Children don't have, so children don't have phones? The children don't have phones? Nowadays, every child has a phone.
Can I say something or no?
Ask your attorney.
Okay.
Judge, can I have a breakout room with Ms. Brown briefly?
Yes. Mm-hmm. Where is breakout rooms?
I can
Alright,
put
you
Ms.
can-
Brown in room 1 with Attorney Rogers.
Yeah, you can just join Attorney Rogers.
Okay, thank you.
And then I'll tell you if you can just go ahead and put Ms. Brown in there for a moment.
Yes, Your Honor.
All right.
Excuse me. Yeah, I think we're good, Judge. I don't know that I'll kind of wait because I know you kind of were, seemed like you were kind of formulating the contours of your ruling. But I just kind of, our concern is just that, to the extent that as it stands, well, basically, I guess just from a practical standpoint, Ms. Brown needs to be able to at least get in touch to let the kids know that they can contact, that she can respond to them when they reach out to her.
Okay, well, I can't.
Yeah, and I'm not
every scenario, but
yeah, we're not to order, Ms. Carter to do anything like that. Like I said, it's just strictly. I'm satisfied with what I heard so far. I appreciate it.
so I can go a little deeper and say that, well, I don't have the other party here, so I can't. I was gonna set a time period for which the kids, that from 5 to 8 or 5 to 7 are the times that she can reach out, but we can't necessarily do that because really that would be ordering someone else that's not a party to this to do something.
So
Okay, hold on just one moment for me. Okay, all righty. So I'm not sure how I can tailor this. But the South Carolina, I think it is, or either Florida court orders still remains in effect. Um, in that hopefully if ADA Thomas talked to her victim and ask her or tell her what the order is, hopefully she'll be able to allow the kids to do that. But there's nothing I can necessarily order. I don't know how I
Hannah,
can
we're
tailor
following
it.
up. I'm following up now with my advocate, and we can let her know what's going on. So when Miss Brown attempts to contact the children, well, ideally she's going to try to contact Miss Carter first, and they can set up the time, the parameters,
Right.
unless the
Right.
court prefers to put that in the order.
What in the order?
And Judge,
The times.
well, yeah, Judge, just kind of responding. I think that's part of the issue that, you know, I think Ms. Brown has tried to like at least get like, you know, some sort of status report just to hear about how they're doing or whatever. And I think that maybe Ms. Carter has not been, you know, facilitated. So I don't.
If you could let ADA Thomas, if you can let her know that the court is asking that she take the initial call and speak so that they can set up something where the kids can communicate with their mother.
Yes, ma'am.
Okay. All right. So I'll be waiting for that order. Yeah, I'll just wait for that order. All right. That's the order of the court. The next one is going to be.
Hey, Judge, Ms. Brown is excused, right?
Yes,
Can I say thank you so much, Judge? Thank
You're
you.
welcome. You're welcome.
I really appreciate it.
All right, and do
Thank
well.
Thank you.
If you keep getting violations, though, the further you're going to get from being around them. So you can't violate. All right.
No,
I don't
this
want
is
you to respond.
misunderstandings, and it's okay. I understand. Thank you. I
All right. Well,
appreciate
good luck to you. You're very welcome. Take care now.
you too.
Thank you, Judge.
All right.
And
And
I
so
believe
next
we
is
have-
Powell.
We have one left.